regulated militia being necessary to the security of a free state, the right of the people to bear arms shall not. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. Hopefully you had a good weekend. We've got a good show in store for you. You know, last week the Supreme Court announced the first of hopefully many Second Amendment-related cases that it will hear this term, Wolford versus Lopez. This is a challenge to Hawaii's quote-unquote vampire rule that prohibits lawful concealed carry on all private property by default. And if property owners want to allow that, they have to either orally tell patrons, hey, you can carry here, or post a sign to that effect. Now, this is not the law in most of the country. In fact, I believe Hawaii is one of 5 states around the country that has this rule in place. And Hawaii, one of, I think, 4 states that adopted this rule post-Bruin in a clear effort to limit as much as possible the ability to exercise our right to bear arms. So taking the position for the plaintiffs during oral arguments and really representing the plaintiffs throughout the entirety of Wolford versus Lopez, a Second Amendment attorney, Alan Beck, who joins us on the program today to talk about this specific case, his other litigation in the state of Hawaii, and what the impact of a good decision in Wolford might be. Take a look and a listen. Alan, thanks very much for coming on the program. It's good to see you, sir.
Thank you very much, Cam.
Yeah, and well, listen, thank you for all the work that you're doing defending our right to keep and bear arms, particularly out west. I got to ask, what was your first reaction when you saw that the Supreme Court had granted cert to Wolford?
I was very happy, that's for sure. I honestly was a little bit surprised just because, it's always it's always a big deal when you never know what the Supreme Court's going to do. They have a lot of cases. This is a very important case, but they have a lot of very important cases that are before it. So even though I thought there was a great chance being granted, I didn't know what was going to happen.
Yeah, well, I mean, you're right. I mean, you've got a circuit court split, which I think, it cuts in your favor and in gun owners' favor. But this is the first time since Bruin that the Supreme Court has taken up the issue of sensitive spaces, right?
That's correct.
So explain, if you can, what Hawaii's, and I'm just going to call it the vampire rule. I know Rob Romano from Farmers Policy Coalition kind of popularized that term. I think if you want to, call it something else, that's fine. But just for the sake of simplicity, I'm going to call it the vampire rule. What is Hawaii's law in question here?
I'm happy to call it the vampire rule, but I think we should explain why Rob Romano calls it the vampire rule if we're going to do so. In mythology, a vampire had to be invited into a building in order to enter it, or at least a building that was occupied by a human being, to be tactical. The reason Rob Romano calls this the vampire rule is because in Hawaii, along with 4 other states, the legislature passed laws after Bruin, which say that when you enter into a private business, the only way that you can enter into a private business with a firearm, even as a concealed carry permit holder, is to gain permission from the property owner that you can enter with a firearm. As a practical matter, that typically means that the business owner puts up a sign saying guns allowed.
Which, as you noted, that's the law in 5 states. Correct. The other 45 states, by default, concealed carry is allowed. And if you, the property owner, don't want concealed carry holders, then you post signage saying guns not allowed.
That's correct. Historically, the law has always been in the United States that there is a presumption that you can carry in a private business open to the public. And if the property owner does not want you to carry, then they can put up a sign or give you a verbal or other form of communication that you're the law historically in all 5 of those states. This is a very new law. This was something written expressly because of Bruin and passed about 2.5 years ago in the 5 states that have enacted these laws.
Yeah, and as you say, enacted after Bruin with an intent to make it as difficult as possible to exercise our right to carry. Right? If you can't have this discretionary issue policy that limits the number of concealed carry licenses, well, let's limit greatly the places where people with these concealed carry license can carry, and then maybe we'll have sort of the same thing, right? Very, very few people exercising their right to bear arms in public.
Absolutely. As a practical matter, businesses simply will not put up these signs because they, this is a very political issue. It might be normal to me and you for a person to come in carry, but the reality is, especially in a tourist state like Hawaii, putting up a sign saying guns allowed is something that's going to elicit a reaction from a lot of people, especially people from other countries. Hawaii gets a lot of tourists from Japan and Europe. And in those countries, it's not a normal thing to read a sign saying guns allowed. And, if you've got a business and the other person next to you has the same business, there's a good chance a lot of those tourists are going to go to the other business. And that's not something that most business owners want to take a chance that most business owners want to take. We have declarations from dozens of business owners in Hawaii. Now, my clients live in Maui, so our declarations are from a variety of Maui business owners, dozens of them, that all say the same thing. We support the Second Amendment. We would like people to be able to carry legally within our business. However, we are not willing to put up that a sign saying guns allowed simply because we know that that's going to hurt our bottom line. And, these are small businesses that operate on margins. So all of them have submitted declarations saying, we'd love for this law to go away. And if this law goes away, we'll be very happy for Maui residents to be able to come legally carry concealed in our businesses.
And if this law goes away, then those businesses that don't want that are free to post signage to that effect, right? This is as I understand it, because I saw some headline from CNN over the weekend that said, how this case could expand carried in malls and businesses. I don't, correct me if I'm wrong, Alan, I don't see any opportunity or any chance that the Supreme Court's going to come back and say private property owners have no right to exclude concealed carry from their property whatsoever.
That's absolutely correct. In fact, the Supreme Court just, I believe, 2 years ago in a case called Cedar Point said that private property owners get to decide, issues like this. And we have not asked for the Supreme Court to say that private businesses have to require people to carry. And there's, Supreme Court precedent dictates that, private business owners will continue to have the right to say guns are not allowed on our property. It's just simply the government should not be allowed to flip this historical presumption. They have a right to exercise constitutional rights on private property. I mean, an example of this, what if there was a presumption that you couldn't pray in a restaurant, and it was a felony to say a short prayer before your meal, quietly, you're not disturbing any of the other patrons, just, a lot of Christians like to say a short prayer, quietly. And now it's a felony unless the business puts up a sign saying Christians allowed, Christian prayer allowed. How would that go over?
Yeah, absolutely. Again, this is about not treating the Second Amendment as a second-class right, which the Supreme Court has repeatedly warned about. And unfortunately, these blue states like Hawaii, I think, are willfully disregarding that message. It's not that they're not getting it. They're getting that message. They're just choosing to ignore it. But I want to get into some specifics of the Wolford case because there are some complexities here. So Wolford originally challenged not just the vampire rule, but a lot of other sensitive places in Hawaii, correct?
That's correct. And while the issue before the Supreme Court is the vampire rule, this litigation continues to be about other sensitive places as well as the vampire rule. And once the Supreme Court proceedings have concluded, we will still be challenging various other parts of it. So the law in Hawaii that the laws that we were challenging, all part of the bill called Act 52, which was passed in 2023, that dealt with that was done expressly in response to the Bruin case, and a case I litigated for 10 years. That out of Hawaii that was heard after Young v. Hawaii, and between that litigation, the state of Hawaii had to pass quite a bit of they had to start issuing permits. They knew it, and they did not want people to be able to use those permits, so they passed this thing called Act 52 that effectively bans carry. This is part of the record in Wolford. In the county of Maui, 96.4% of the publicly accessible land on Maui is a sensitive place, pursuant to Act 52. Now, the U.S. Supreme Court says that in Bruin that sensitive places is supposed to be the exception. 96.4% does not seem like an exception to me. That seems like the norm.
Yeah, absolutely.
So what we're specifically challenging is a law that says you can't carry in parks and beaches. And to be clear, we're not talking about just the public park with swing set next to your house. We're talking about thousands and thousands of acres of remote, rural land that the state happens to own and calls a park. Thousands of acres of, undeveloped land just happens to be out in rural Hawaii. And the beaches at issue here aren't just, the popular beaches you might think on a Hawaiian postcard. Most of these beaches are places where you're not going to see another person if you hike down. I've lived in Hawaii. I've spent most of my life going to Hawaii, and I've worked there for most of my adult life as well. And it's very simple. It's the government in this case would like to paint this out as not wanting carry in these, where there's you're shoulder to shoulder with other beachgoers, on the streets of, on the beaches of Waikiki. Now, don't get me wrong, I think you should be able to carry there too, but the picture they're painting is not the same as reality. I mean, in the outer islands of Hawaii, on the Big Island, County of Maui, where my clients live, there, most of the coastline it happens to be a beach, and it's not beaches where the police are going to be able to get to you right away. It's a lot of this is fairly isolated areas,
Right.
And so we're challenging that restriction. We're challenging the ban on restaurants that serve establishments that serve alcohol, and a large part of that is restaurants that serve alcohol. People, the government would like to paint this out to be some crowded nightclub. The places my clients want to go to are, just essentially every diner in Maui, or at least 90% of that. I'm making that statistic up. I'm just saying the vast majority of diners serve beer. How many Italian restaurants do you know that don't serve wine?
Right.
And when I was growing up, I played soccer as a little kid. And after the soccer game, you go to Round Table Pizza right down the street from my house. They happen to serve beer there, and the vast majority of people that go to Round Table Pizza after their kid's soccer game are not, getting drunk, maybe the person's not driving, has one beer. That is not, some type of sensitive location that, as Supreme Court envisioned it.
Yeah.
It's so they've banned carry in the vast majority of restaurants. And as that applies to my clients, I mean, let's say you've got your lunch break, you got an hour to go get lunch. You have to map out which restaurant, doesn't serve alcohol, and that's a beer, that's wine, right? That's not you drinking. And, a lot of times you won't even see anyone drinking during the lunch hour because, it's lunch hour, but they happen to serve them there. And so you've got to figure out some way to figure this out before, or else you're committing a felony.
Well, not only that, you got to find those restaurants that have posted signs. Well, okay,
absolutely,
actually,
you're right.
Theoretically, you do, but I want to get into that, right? Because at the moment, that is not the case. So let me ask, Alan. You talk about these other sensitive places that are still being challenged. So this case has reached the Supreme Court. The Supreme Court has granted cert before this has been fully decided on the merits, right? We're still in the injunctive stage of this lawsuit.
That's correct.
Which is, I think, unique. I mean, again, the Supreme Court, has said we kind of want to take a wait and see approach. We want these things to be fully fleshed out. So I think it's additionally interesting that they took this case at this stage. But because we're in the injunctive stage, there is currently an injunction against the vampire rule that is in effect in Hawaii, correct?
That's correct. And there's an injunction against the state's prohibition on beaches, banks, restaurants, establishments that serve alcohol, and a variety of parking lots. We received a temporary restraining order that was converted into a preliminary injunction in the trial court.
Okay.
We went to the Ninth Circuit, and the Ninth Circuit denied the government's initial motions, and they didn't attempt to. After that one was denied, they didn't ask for a second motion to stay. So that injunction stayed into place. We went to the Ninth Circuit. The Ninth Circuit ruled, and we lost in front of the Ninth Circuit. So a lot of people thought that the injunction went away. However, what happened is I drafted and filed a motion to stay the mandate of the Ninth Circuit pending resolution of Supreme Court proceedings. The Ninth Circuit granted that motion, which means the Ninth Circuit's order is not in effect right now until the U.S. Supreme Court decides this case. So right now, the original trial court decision put into effect is still in effect.
Okay, that is good news, and I think it's important news for people who are either residents of Hawaii or who are visiting Hawaii. Although, given the lack of reciprocity with concealed carry in Hawaii, that's right.
That lawsuit's in the pipeline, Cam.
There you go. So the other twist of the Ninth Circuit was California is one of the other four states that has a quote unquote vampire rule in effect. The Ninth Circuit had previously said that California's vampire rule does violate the Second Amendment, but Hawaii's doesn't. So what's the difference between these two rules, Alan?
So California put in more restrictive vampire rule than Hawaii did. Hawaii's vampire rule is identical to New York's, New Jersey's, and Maryland's. And Hawaii law says you have to receive some form of permission, either in the form of a sign being put up or verbal or permission from the owner.
Okay.
Whereas California law only allows permission through a sign being put up.
Okay.
And the Ninth Circuit thought there was a distinction between the two of these. I don't see it. And I think the more practical reason is
Yeah.
California law was unique, and Hawaii's law was the same as New York, New Jersey, and Maryland's. And, I don't know this for a fact, but I suspect that since California was off on its own and Hawaii's was in uniformity with New York and the other states, this was the Ninth Circuit trying to signal to California that, look, everything's fine. You just need to rewrite yours to be the same as New York's and New Jersey's.
Okay.
Yeah.
Okay.
And it gave the Ninth Circuit an opportunity to look reasonable because, look, we're striking one,
Yeah. Well, so what's interesting is that after the Supreme Court granted cert, I went back and I reread the Ninth Circuit's decision in Wolford. And again, I'm not an attorney, Alan, so I'm gonna ask this question to you. The two laws that the Ninth Circuit cited in Wolford as their main justification for upholding the vampire rule, there was a 1771 statute from New Jersey that barred people from carrying basically anywhere unless they had written permission from the property owner. And then there was I believe it was 1868 law from Louisiana that barred 1865. Okay.
Yeah.
This was part of the Black Codes. I mean, and let's just be blunt about it. These were the laws that were put in place right after the Civil War by people who, frankly, the power structure in Louisiana who didn't want to see freed slaves carrying guns. Thought that was a bad thing, but they had that blanket prohibition on carrying unless you had permission by the property owner, the owner of the plantation. And the Ninth Circuit panel called these historical twins. That was the word that they used. These are historical twins to Hawaii's law. And yet these laws aren't even historical twins to each other because, as I understand it, the 1771 statute from New Jersey said that it had to be, I think it was explicit written permission, right? And then the Louisiana law didn't make any distinction between written or oral permission. It just said that you had to have permission from the property owner.
Well, the law of 1771 is the anti-poaching law.
Okay.
It's part of a section that says, I'm paraphrasing, but laws against the laws against deer hunting, right? And and the Ninth Circuit cites to a subsection of the section that talks about needing permission on the from the property owner.
Okay.
But within the context of of this larger section, it's very clearly a law designed to prevent poaching.
So this was basically Hawaii's law was basically upheld. A national tradition, quote unquote, was found as a result of a 1771 law from New Jersey against poaching. And by the way, New Jersey was a colony at the time. And then an 1865 law from Louisiana. Those two statutes constitute a national tradition of being able to ban guns in all publicly accessible private places by default.
Well, exactly. I mean, the Supreme Court made it pretty clear, Bruin, they need more than two laws. And that was the best the Ninth Circuit could come up with.
Yeah,
this was a results. There was a result they wanted to come to, and the fact is, this is the best they could come up with was two laws. One that was talked about, if you're going on someone's land to hunt, you need permission. That's not unreasonable,
right?
But and a law that said that something about the 1865 Louisiana law is it's Louisiana was not part of the Union. This law was put into place. The law had just and I could be a couple years off with 1865, by the way. So but the point is, Louisiana had just lost Civil War, and there was a 2-year period before they had re-entered the Union, where they were trying to they were trying to figure out what they were going to do when they rejoined the Union, because they knew that they would have to give rights to freed African American slaves. And this was done. To me, I think it can't be part of an American tradition if the place was not part of America yet. I mean, that's one thing. And two, we've got there was an excellent amicus brief filed by an attorney whose name I butcher on a fairly regular basis, Costas Moros.
Mm-hmm.
That's and he always puts up with the fact that butcher. Anyway, he's an attorney for the Second Amendment Foundation, and he produced evidence that where the governor of Louisiana very expressly said, "This is why we're passing this law. We have to do something about freed African American slaves, be able to have constitutional rights and firearms rights." And it's to me, I think it's this is not something we really need to be hanging our head on in terms of justification for a law.
Yeah, right. Absolutely. And so this gets to, another question here. In the cert petition, originally there were two questions that were presented to the court. One, about the constitutionality of the vampire rule itself, but then two, what is the time frame for courts to be looking at here, right? Is it 1791? Is it around or after 1868 when the 14th Amendment was ratified and the Bill of Rights was applied to the states? The Supreme Court said, we're going to answer question one, but they didn't say anything about answering question two. Do you think the court is going to have to touch on the time frame at some point? I mean, because again, just based on the facts of this case, it seems to me like it's going to be very difficult for the court to avoid any mention of the proper time frame for the courts to be looking at here.
I think the court's absolutely going to have to delve into the methodology that needs to be used to evaluate a constitutional challenge after Broome. Especially in light of the fact that the Louisiana law is from the 19th century, and that's just something the court is going to want to talk about. I think the second question presented in our cert petition dealt with our challenge to parks and restaurants that serve alcohol. So I think that's probably the larger reason that the court decided to avoid that issue and focus on question one. So, I mean, I think in the process of answering question one, it'll be able to, address, it will need to address, what is the proper time frame.
Okay. Well, speaking of time frame, we are unfortunately going to be running out of time here soon, but let's talk about the general timeline of this case, right? So the first round of briefs are due before the Supreme Court in about a month or so. Is that right?
45 days from last Friday, from when the cert petition was granted.
Okay.
I have to file an opening brief.
Okay. And then the state of Hawaii will have an opportunity to reply.
Yes.
You get to reply to their reply, right?
Yes.
And then we'll see a ton of amicus briefs filed by all kinds of interested parties on both sides. Oral arguments, I don't think we've got a date for them, but presumably they'll be sometime in the spring, and we would expect a decision before the court breaks for its summer recess.
I'm expecting oral arguments to be a little sooner than that.
Okay.
The earliest could be December. More likely, it'll be in January.
Okay.
That's just the Supreme Court's calendar is booked through November right now.
Okay.
So it has openings December, but it's more likely than not they'll push it off to January before they order anything, before we have more arguments.
Okay. Well, listen, again, Alan, I'm so pleased that you're going to be arguing before the Supreme Court here. We have not had a chance to talk much about the plethora of litigation that you are involved in Hawaii. But I mean, honestly, we've written about it a lot of Bearing Arms. You have an outstanding track record of, curtailing some of the abuses that continue to be launched by Hawaii lawmakers. So thank you for keeping up, the fight, not just with the Wolford case, but with so many other ongoing lawsuits here. And I would love to be able to reach out and talk to you about some of these other cases in the weeks ahead as well.
Absolutely. I'd love to. Yeah.
Awesome. All right. Well, listen, Alan, thank you again for your time. Thanks for everything you do. And I look forward to talking again very soon.
All right. You have a great day, sir.
Thanks. You too, Alan. Alan Beck joining us here on Bearing Arms Cam & Company. Thanks to Alan for joining me on the program. Looking forward to talking to him again very soon. Right now, let's turn our attention to today's Armed Citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Jacksonville, Florida. Man who hit and killed Jacksonville teen tried running over a man months prior, court records say. In fact, he was on apparently an ankle monitor at the time of this most recent, hit and run, right? 13-year-old Genesis Weber was killed. 54-year-old Andre Myers arrested a day after the crash. And First Coast News in Florida says it's been digging into his criminal history, uncovered information that raises serious questions about why he was ever behind the wheel in the first place. According to the Jacksonville Sheriff's Office, Myers was found asleep in his truck late Wednesday night. He was wearing a GPS monitor. He was out on a bond from a crime committed back in June. An arrest report from June 1st shows that Myers was charged with aggravated assault for attempting to run over a man with his car at a car wash there in Jacksonville. The report says he chased the man around the parking lot, threatened to kill him, and then drove his car at him. According to court records, though, Myers also, beyond that incident, has a, quote, lengthy rap sheet that spans back nearly 3 decades, including battery, speeding violations, and at least 6 different charges of driving with a suspended license. But despite that history, the Jacksonville Sheriff's Office says that Myers was out of jail. He was driving again. Ken Jefferson, who is the crime and safety expert for First Coast News, says this shouldn't have happened. He said 2 things came to my mind when I saw that, is that he has anger issues and he's a habitual traffic offender who never, ever should be allowed to sit in a vehicle and drive whatsoever. He says that's all on the judicial system. The officers did their job when they pulled him over and realized that he had a suspended license. Once they make that arrest and put him in the system, that's all that they can do. Jefferson says the only thing I can think of how to address this is to put him behind bars for a long time, which I agree with. But again, I mean, yeah, you can suspend the guy's license, but as long as he has access to a car, he can still get behind the wheel and break the law, right? I mean, we talk about the same thing in terms of gun control all the time. You can make somebody a prohibited person. You can tell somebody they can't own a gun because of a red flag order, but this means they can't legally own a gun. If they're a violent criminal and they don't care about breaking the laws against, let's say, murder, armed robbery, home invasion, carjacking, I don't really think they're going to care about illegally carrying a gun. That's not the issue, right? The individual is the issue. And this is yet another example of that in Jacksonville, Florida. Now, today's Armed Citizen story from San Antonio, Texas, where a masked robber was shot after trying to rob a vape shop over the weekend. According to San Antonio Express News, this was Saturday night. The suspect at last reported in critical condition. The masked man, not identified by police, at least as of Saturday evening, was trying to rob the Pal Vape dispensary around 11 o'clock Saturday night, armed with a handgun, according to San Antonio police, who says the robber was, quote, displaying his handgun at the victim, demanding property. But the 29-year-old vape shop worker who was being threatened pulled his own firearm and shot the masked robber multiple times. San Antonio police responded to the shop for a robbery in progress. The robber, identified only as a 34-year-old man in the police report, taken to the hospital with life-threatening injuries. The store employee, not injured, thankfully. Police say this is an ongoing investigation, but based on the report so far, this would appear to be a clear-cut act of self-defense, and I doubt the store owner is going to face any charges whatsoever, but we'll keep our eyes open for any more details as they become available. Finally, today, in the right place at the right time, willing and able to do the right thing, an anonymous woman who helped save a man injured in a knife attack on a Greyhound bus. Very reminiscent of this attack in Charlotte, North Carolina a few weeks ago. Jorge Quintanilla was on the bus going from Alamogordo, New Mexico to the Old Pueblo on September 29th when he was attacked. The New Mexico Department of Public Safety says 29-year-old Ryan Kinney, arrested on a charge of aggravated battery with a deadly weapon. Quintanilla and his sister Adriana Velasquez, say they're looking for help to find this Good Samaritan who saved Quintanilla's life in the moments after the stabbing. Quintanilla says, he said, I just suddenly heard somebody moving quickly on the other side of the aisle from me. When I looked over, it was this guy who was lunging across the aisle with what I thought at the time was a pen. He said, and he stabbed me straight in the neck. And then after that, I was able to grab his wrist and I was trying to push him off of me. And in that time, he kept stabbing and jabbing, and it was more towards the head. Quintanilla was ultimately stabbed 6 times in the head, neck, and arm. When first responders finally arrived, he actually had to be airlifted to a hospital in El Paso to have his injuries treated. He is thankfully expected to recover. But Quintanilla says, I just seen this attack in Charlotte, talking about Irina Zarutska. He said, I'd seen it all over social media. He says, that was scary enough. He said, the poor girl, she had no help. Nobody noticed what had happened with her attacker. They just left her there. Quintanilla said everybody at the hospital was comparing the attack on him to what happened to Zarutska. He said, it's pretty much exactly how it went down. Somebody just decided to grab a knife and attack me. In this case, though, there was one difference. There was a Good Samaritan on that bus, an unidentified woman who stepped up, applied pressure to Quintanilla's wounds, who helped staunch the bleeding. Quintanilla says, I keep calling her my guardian angel because she was an absolute commander. He said, without her, I don't believe I would have made it the 20 minutes that it took for paramedics to get there. He doesn't know who she is, and he and her sister are asking, if you know who she is, let them know. He's saying, so thankful to her. Thank you so much, whoever you are. So, again, in the right place at the right time, willing and able to do the right thing for a stranger in need, this anonymous Good Samaritan on a Greyhound bus in New Mexico. Greyhound, by the way, not commenting on how the knife was brought aboard, but it's not like you have pat-downs or metal detectors when you get on a bus. These are supposedly weapons-free zones, but it's only folks who want to abide by the rules of Greyhound who are going to follow that. And in the meantime, I think this is another case for being able to protect yourself. In this case, on private transportation, but certainly on public transportation around the country. I'm glad that Mr. Quintanilla is going to be okay, but even more grateful again for that Good Samaritan being able to step up when needed. That is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program as always. And don't forget to check out bearingarms.com throughout the rest of the day today, keeping up to date on all of the latest Second Amendment news from across the country. Also have a big special going on while the government is shut down. Use the promo code POTUS47 and you can get 74% off your VIP Gold, or VIP Platinum memberships. You get all kinds of great benefits at every tier of support. But we certainly do appreciate your support for Bearing Arms. Thank you again. And please take advantage of that special savings if you have not done so already. We'll see you back here tomorrow. Until then, have a great rest of your Monday, as well as Mondays can be. Do well. Be safe. And be free.